everyone, and welcome to Registrar Corp's webinar entitled 5 Things Food Exporters Need to Know in 2020. My name is Clay Blondin, a marketing specialist at Registrar Corp and today's moderator. The presentation will conclude with a live questions and answer session. If we run out of time, we are also happy to respond to your questions by email. You may submit a written question anytime during the webinar by using the Ask a Question feature in the top center of your webinar screen. A recorded copy of this presentation will be sent to all registrants. I'd like to introduce our speakers today. Mary Hancock is a graduate of Appalachian State University and has worked for nearly 10 years in FDA regulatory compliance. She began her career with Registrar Corp in 2009 and is currently the director of Registrar Corp's Food Facility Registration Department. Anna Benavente holds a Bachelor of Science degree in biology from the College of William and Mary in Williamsburg, Virginia. Ms. Benavente has over 10 years of analytical research experience. She's been assisting companies with U.S. FDA regulations since 2009 and acts as director of Registrar Corp's labeling and ingredient review team. Fabiola Negron holds a Bachelor of Science in Industrial Microbiology and pursued graduate coursework in Food Science and Technology at the University of Puerto Rico. Ms. Negron acts as Registrar Corp's Manager of Food Safety. I'd like to go ahead and begin. Mary?
Good morning, everybody. So let's start off our webinar this morning talking about FDA's new unique facility identifier requirements for the 2020 renewal period. FDA has stated that a new requirement for all registered food facilities, both foreign and domestic, will go into effect starting in October of 2020. This requirement is for a unique facility identifier, or UFI. FDA intends to use the UFI to verify the data provided to the agency in food facility registration submissions. FDA has stated that it plans to recognize DUNS numbers as acceptable UFIs. DUNS numbers are a unique 9-digit identifier for businesses and are issued by the private company Dun & Bradstreet. Dun & Bradstreet provides commercial data and analytics for businesses. The agency has stated that other UFIs may be accepted, but has not identified any alternatives at the present date. FDA will provide guidance with the specifics of the pending UFI requirement. For example, many companies have one DUNS number that represent multiple locations under the same ownership. And at this time, it may not be clear whether one DUNS number for a company's headquarters would be accepted for each individual facility in a group of companies, or whether each facility must obtain its own unique DUNS number. Registrar Corp will provide additional updates regarding the UFI requirement as FDA releases further details. The agency has stated in guidance that it will not confirm a facility's biennial registration renewal until verifying the accuracy of the facility's UFI. So let's talk about the biennial food facility registration renewal. The Food Safety Modernization Act of 2011 includes a requirement for all registered food facilities to renew their registrations between October 1st and December 31st of each even-numbered year. Any registration that fails to renew prior to the deadline is removed from FDA's database, leaving behind, in theory, only accurate and current facility data. FDA uses the data provided in its food facility registration database to contact facilities for both routine communication, for example, related to scheduling inspections of facilities, and emergency communication related to potential outbreaks of illness, for example. Food facility registration data is also used by FDA to assess a facility's risk level and plan facility inspections accordingly. The next biennial registration renewal period is scheduled to begin on October 1st of 2020. DUNS numbers can sometimes be obtained or updated in as little as 7 to 15 business days, but this time can vary greatly, even taking months to reach a resolution sometimes. To avoid delays in your shipments to the United States or delays in FDA's confirmation of your mandatory biennial registration renewal, make sure to apply for your DUNS number in advance of the renewal period. Registrar Corp clients can verify or request a DUNS number by logging into their accounts at myfda.com. As outlined in 21 CFR 1.231, FDA will not provide you with a confirmation of your registration renewal until FDA verifies the accuracy of your UFI and verifies that the facility-specific address associated with the UFI is the same address associated with your registration. After the 2018 renewal period, over 10% of registered food facilities were removed from FDA's database for failure to renew. Registrar Corp's regulatory specialists can assist you with obtaining or updating a DUNS number, as well as submitting your biennial FDA food facility registration renewal in 2020.
Good morning, everyone. This is Anna Benavente, and I want to thank you for participating in our webinar. We're going to be moving on to food labeling requirements, which is sometimes an afterthought to many exporters, but is critical in ensuring that products find their way to the U.S. market without any problems. Your food label is the first thing that an inspector may see, and it's important that it be in compliance with FDA regulations. So these are going to be the basic requirements for your food label. These are the mandatory declarations that FDA states need to be on the product labeling as it enters port. First and foremost is going to be a statement of identity. This is a statement that accurately identifies the product within the container. So for example, most of us are familiar with Oreos, which if I say Oreo, you know what I'm talking about. However, Oreo is not a statement of identity. The statement of identity for Oreos would be chocolate sandwich cookies. So it's important to understand that you need to have a clear and succinct statement that identifies the product and not rely on trade names or brand names. Second up, we have a net quantity statement. And so the net quantity is going to be the amount of product within the container. It will need to be declared in both avoirdupois or the imperial system, and then also in our metric system. Should be in either numerical count, solid measure, or fluid measure. An ingredients list that is complete must also be present on the labeling. In some countries, for example, you're permitted to omit certain preservatives or colors and so forth, but this is not the case in the United States. Need to make sure that in most cases, every ingredient is identified by its proper common name, not just by its function, on the ingredients list on the labeling. FDA also has requirements regarding certain allergens and a statement that must be made if present as an ingredient in the product. The manufacturer, distributor, and packer identity must be declared. In most cases, you can choose whichever one of those three that you wish to have declared on the label. It will need to be the corporate name and the full street address, not a P.O. box, of the entity. U.S. Customs will require a country of origin statement, identifying the last country where substantial transformation took place for that particular product. There are additional requirements when you have additional languages besides English on the label. And then the most complicated part of an FDA food label, the nutrition facts panel, unless the product is exempt. And then just when you think that you've got it, FDA changes it. On January 1st, 2020, the first compliance date passed for a set of rules that dramatically transformed United States food labels. So our food labels were replaced by a new version. Now this version is dramatically different from the original that was passed and put into regulation back in 1990, so many, many years ago. So FDA updated it to address certain concerns there are about the American diet, to address the nutrients that FDA considers to be important, that consumers have access to those values in order to maintain good dietary practices, and then to also highlight certain things like the amount of calories as well as total fat, saturated and trans fat that are important for people to consider when they're choosing foods and wanting to maintain healthy dietary practices. Okay, so now the question is, when do you need to comply? So the rules came out quite a few years ago, back in 2016, and became effective. However, FDA does allow time for companies to bring their product labels into compliance. So your compliance date is going to be based on the annual global food sales of the manufacturer. And FDA will have two distinct dates, one for larger businesses, one for smaller businesses. Now, originally, companies were going to need to come into compliance in 2018 and 2019, but FDA did grant an extension. So the new deadlines were January 1st, 2020 for companies with sales greater than 10 million, and then January 1st, 2021 coming up for smaller companies that have annual global sales of less than 10 million. Now, for those of you who are familiar with the old version of our nutrition facts panel, it's important for you to understand the changes to the content. It's not simply a matter of just enlarging some type sizes and moving on. For example, because FDA evaluated the average American diet to determine what sort of nutrients were of a concern in terms of their levels in the average American diet, vitamin D and potassium were made mandatory declarations for the label. This means that a food manufacturer must know the amount of vitamin D and potassium, and if present in a significant amount, declared on the label. Vitamins A and C are now voluntary because their levels in the average American diet are no longer a concern. And so they do not have to be declared on the nutrition facts panel. Americans get plenty of vitamin A and C, so not a big deal anymore in the same way that vitamin D and potassium are a concern. FDA also has declared that calories from fat, not only is it not voluntary, but it can't be declared, period. This comes from new research that show that it's not the calories from fat that is important, but rather the type of fat. New research, of course, shows that certain fatty foods, such as salmon and nuts, have beneficial fats to the American diet. And so that should be acknowledged. And calories from fat is really not considered useful information anymore. Fluoride can now also voluntarily be declared, especially if you're adding it to bottled water. You can include it in the nutrition facts panel. And sugars is now being declared as total sugars. This is to distinguish it from added sugars. Added sugars is a new declaration that is present in the nutrition facts panel and must be declared when it's present at certain amounts. There's sort of a tricky definition for added sugars. Generally speaking, it means any additional sugars, fructose, sucrose, galactose, any free mono or disaccharides that have been added to the products, most likely are going to be ending up in that added sugars declaration. There are some exemptions when you're adding whole fruit, fruit purees, fruits themselves have additional nutrient value, and so FDA decided not to include them in the added sugars declaration. If you have questions about whether or not your product's sugars would be considered added sugars, I do encourage you to reach out to Registrar Corp because we can assist with this. Some other changes to the content. The 4 mandatory vitamins and minerals now must be declared by quantitative amount rather than just the percent daily value. Modifications on how folate and folic acid are declared were maintained and included. New units for vitamin D, niacin, vitamin A, and vitamin E were also implemented as well. Some of the other changes, a more restrictive definition for dietary fiber was implemented. Prior to the new rules, dietary fiber was just kind of declared and defined as dietary fiber. Well, now FDA has a much more expansive definition. In essence, fiber that's intact in plants is included, but only certain isolated fibers, such as inulin, can be included in the dietary fiber quantitative value that's declared on the nutrition facts panel. FDA also made changes to the daily reference values and the recommended daily intake values upon which the percent daily value is calculated. This again is based off of new research about the types and amounts of these nutrients that are necessary for a healthy diet. So, for example, they raised the amount of potassium to 4,700 milligrams. They actually increased the total fat to 78 grams, but then decreased the total carbohydrate from 300 down to 275. So some changes there. So again, updating your nutrition facts panel, if that's what you're doing, isn't a matter of just changing the format. It may mean recalculating certain values because of this. Also, because FDA changed the serving sizes for some foods, it's important to understand that The FDA established serving sizes are based on consumer data about what Americans actually eat, not what they should eat. So, for example, the old serving size for ice cream was a half a cup. I personally never eat only a half a cup of ice cream, and the new serving size for ice cream reflects this. It has been increased to 2/3 of a cup. They also established a new serving size for appetizers. They modified the beverage serving sizes to reflect certain beverages, such as milk and juice, where the average consumer would take in about a cup, versus sodas, waters, coffee, and tea, where the average consumer brings in about 360 milliliters. So the serving sizes have been changed to reflect that as well. Now, the format changes are also pretty substantial. You can take a look and see that we've got an order, changes to the order of nutrients. So, for example, potassium, which is now at the bottom of the chart, used to be up with sodium and cholesterol. Again, those new mandatory nutrients, vitamin D and potassium, have been added to the standard chart. They made changes to the footnote. That percent daily value footnote that's at the bottom of the chart is different. They've made changes to the font sizes of the declarations. It's hard to ignore that huge calorie count that's up there at the top, whereas previously it was in the same type size as the remainder of the content of the chart. So caloric intake is a public health concern in the United States, and so FDA wanted to make sure that that calorie declaration was prominent on the nutrition facts label. Then, as I mentioned before, the quantitative amounts of the vitamin D, calcium, iron, and potassium are now actually declared, not just the percent daily value. Now, a brand new requirement, it's not a matter of just changing an old requirement, but a brand new one is dual column labeling. Previously, FDA had dual column options for things like cereal, where you could declare the amount of cereal and then the nutrient value when you added a cup of milk to it. But there wasn't a lot in terms of requirements for dual column labeling. This has changed dramatically, and it will impact products that are in packaging that's 200 to 300% of the reference amount. Or products that are in discrete units that are 200 to 300% of that reference amount. So these are two examples. So the one on the left, you can see you've got a per serving as well as a per container declaration. And so this might be, for example, a package of chips that is 75 grams. So it's in between 200 and 300% of the reference amount. FDA based this rule to accommodate for when consumers have packaging that could conceivably be consumed in one sitting. So they did their research, they looked at a lot of data, they figured out that containers that are between 200 and 300% of the reference amount could conceivably be consumed, and they wanted that nutrition for the entire container to be presented in the dual column label. Likewise, most of us are familiar with the muffins, that they serve at Starbucks that are about the size of your head. And so those are way in excess of what the reference amount for muffins are. So in the right-hand side, you can see the dual column is for a muffin where the entire muffin, hence the unit, is between 200 and 300% of that reference amount. FDA rules will require that you declare the serving size according to that reference amount, so half a muffin, but then also the nutrient values for the entire muffin. Now, these are some of the common mistakes that are made. Oftentimes, products that come in that end up detained for labeling violations, it's the name of the food doesn't conform to FDA's requirements. So a common issue are with what are called standards of identity. You have certain types of food, everything from jam to ice cream to mixed nuts, where FDA has a definition for that exact food. And if the food doesn't conform to that definition, it cannot be called by that name. So if you ship that product and FDA inspects it and determines that this is the case, they can consider it misbranded and not let it in unless a labeling change is made. Other requirements that FDA has for things like artificial flavors might have to be incorporated into the name, things like that. So it's important to know what the rules are for how you name your food before you ship it. Other common mistakes: when net quantity statements don't include the ounce and pound and rely solely on the metric declaration, or they're not placed correctly on the label. For example, our net quantity statements must be on the front panel, but it's quite common in other places in the world that it's sufficient to have it on a side panel or the back panel. So that can cause a problem in port. Oftentimes we see products that are stopped because they have incomplete bilingual or multilingual labeling. FDA requires that all the mandatory declarations be presented in that second or multiple languages. So if you have only part of the label in Spanish and none of it in English, then you're going to really run into a problem there as well. The incorrectly formatted nutrition facts panel. That nutrition facts panel is tricky, and there are a lot of strange little rules that govern it. And so if you don't have it formatted correctly, then you can run into a problem. And oftentimes people are simply unaware and ship without having a properly formatted nutrition facts panel. So, for example, coming out of the EU, it's common to have the nutrition facts that are declared per 100 grams, but this isn't sufficient for the United States. The nutrition information has to be presented in the context of FDA serving size for that food. Some other common issues: ingredients have to be declared in most cases by their common name, so using an E number is not appropriate and can cause a detention. And lastly, ingredients that are not permitted in the US but are permitted elsewhere in the world. Color additives, I would say, are the most common issue. For example, Ponceau 4R, used plenty of countries around the world. No safety concerns that I'm aware of, but however, it's not approved as a color additive in the US. So the presence of Ponceau 4R in a product causes it to be adulterated, and if it's stopped in port, they simply will not permit it to enter. Okay. Moving on, there's actually a new requirement on the horizon. This one's courtesy of our USDA, but it will impact FDA-regulated food products, actually, ironically, more than USDA regulated food products. And it has to do with bioengineered food. Bioengineered food is defined by USDA as food that contains genetic material that has been modified through in vitro recombinant deoxyribonucleic acid techniques, and for which the modification could not otherwise be obtained through conventional breeding or found in nature. So now the issue is that USDA has been tasked with implementing a mandatory disclosure standard. And so this is sort of what they came up with. It's to address foods that are certainly or may be bioengineered. So it's going to apply basically to all human foods subject to FDA's jurisdiction and some that are subject to USDA's jurisdiction. USDA did do us all a favor and develop a list of bioengineered foods that may trigger this disclosure requirement. So it's important, though, to understand that it includes some very common ingredients, such as corn and soybeans. The presence of these ingredients in your product most likely are going to trigger this bioengineered disclosure. Companies also have to disclose if they have, quote unquote, actual knowledge of a bioengineered ingredient, even if it is not on USDA's list. Now, there are some exemptions. It's intended for human food, so not pet food or animal feed products. It does not impact alcoholic beverages that are regulated by our TTB, which would be most of them. Some of the alcoholic beverages that will be impacted, though, would be wines that are less than 7% alcohol, and certain beverages like fruit beers that are not made with barley and hops. Meat, poultry, and egg products, which are generally regulated by USDA unless they have small amounts of meat and poultry and egg, in which case they're subject to FDA regulations. The meat and poultry regulated by USDA are not going to be required to declare the bioengineered disclosure. Also, incidental additives and processing aids. And then also foods on the list in cases where the manufacturer has documentation that there is no bioengineered material present. So for example, if a manufacturer can prove that the corn oil that they're using is so highly refined that no DNA is present, they may be exempt from the disclosure. Also, if they can prove that their corn has no any bioengineered material in it at all, if somehow it was developed without using bioengineered material, then they may also be exempt as well. Some other exemptions: food served in a restaurant or a similar retail food establishment. Some other similar exemptions to the nutrition facts panel: very small food manufacturers, inadvertent and technically unavoidable presence of bioengineered substances up to 5%. Importantly, food derived from an animal that was fed with bioengineered products. So for example, if the chicken was fed corn, the meat from the chicken does not have to have that disclosure. And foods that have been certified as organic are going to be exempt from the bioengineered disclosure. So this is what the disclosure in essence is going to look like. You have a couple of different options. You can have a text disclosure, a symbol on the labeling, electronic and digital links, and then also a text messaging option. To the right, you see the symbol that USDA has generated for this purpose. The requirement is that it appear prominently and conspicuously on certain panels, and there are some exemptions for small manufacturers and small packages as well. USDA also allows for certain voluntary disclosure options for either products or manufacturers that normally would not be required to disclose. Now, these are the compliance dates. USDA has what they call an implementation date, which was January 1st for larger manufacturers, 2020, January 1st, 2021 for the smaller companies. The actual compliance date where labels will be subject to jurisdiction for this purpose, January 1st, 2020.
Hello, everyone. We will move along with the intentional adulteration rule. The IA rule is found in 21 CFR 121 and is officially called the mitigation strategies to protect food against intentional adulteration. This rule applies to the FDA registered human food facilities who make 10 million or more. This is also commonly known as food defense. If you're already familiar with the preventive controls rule, you will note similarities in terms of the preventive approach, but instead of focusing on minimizing or preventing the significant biological, chemical, or physical hazards associated to the type of food or process, which are unintended, it focuses on the intentional adulteration of food. Food defense will focus on significantly minimizing or preventing significant vulnerabilities related to the intentional adulteration of food by someone whose purpose is to cause a wide-scale harm to consumers. In summary, it could be to harm the company, its reputation. Certain activities are exempt from complying with this rule. One of them is very small businesses. A very small business is one that averages less than 10 million adjusted for inflation per year during the 3-year period preceding the applicable calendar year in sales of human food, plus the market value of human food manufactured, processed, packed, or held without sale. This includes any subsidiaries and affiliates. You must, upon request, provide for official review documentation sufficient to show that the facility meets the criteria for the exemption. Such documentation must be retained for 2 years. We move on to holding of food. There are certain foods that are harder to contaminate, therefore less likely to cause a wide-scale harm to the consumer if somebody were to attempt to contaminate it. Examples of holding of food that are not covered by the IA rule include the storage of whole grains, shell eggs, fruits and vegetables, and packaged foods. Packing, repacking, labeling, or relabeling, where the primary packaging is kept intact, the packing should not be confused with packaging. An example of packing is placing a variety of individually wrapped bite-sized candies into a larger variety pack, whereas packaging is placing the food in the container that directly contacts the food, or its primary packaging that the consumer receives. So if you're just packing something that is already pre-packed, then you would be exempt from this regulation. Covered farms are those that are subject to the standards for produce safety, and these farms grow and harvest produce that is likely to be consumed raw. For example, lettuce, tomatoes, cucumbers, apples, bananas, etc. Alcoholic beverages. This exemption applies to facilities that have the required permits, registrations, and approval from the United States Secretary of Treasury, and is also registered as a food facility with FDA. Animal food. If a facility manufactures, processes, packs, or holds food for both humans and animals, only the activities related to the human food will be covered by the rule. Then farm mix type facilities are those that meet the definition of a farm, but also engage in activities that fall under the definition of processing. So here in this diagram, we can see the food defense components as well as other essential elements required for a compliant food defense system. The food defense components are as follows. A vulnerability assessment. You must identify mitigation strategies, establish monitoring procedures, corrective actions in case of a deviation, and verification procedures for verification activities. You will not be fully in compliance unless you also assign a food defense qualified individual to perform the critical activities required as part of the food defense plan. If you must keep records of all activities related to the food defense plan, and you must do a reanalysis of the food defense plan. This document needs to be updated as changes take place in your facility that may create new vulnerabilities. In the following slides, I will briefly explain each of these components and elements. So a food defense plan is a set of written documents that is based upon food defense principles and incorporates a vulnerability assessment, mitigation strategies, and delineates the food defense monitoring, corrective actions, and verification procedures to be followed. The food defense plan contains the information that presents sensitive facility information, not likely to be included in food safety plans or other GMP documentation. You must make sure that you do not share your food defense plan with anyone and keep it somewhere safe. If this information falls into the wrong hands, it may put your facility at risk of an attack. A food defense qualified individual must be designated to write the food defense plan, and they would be the most qualified individual, like the leader of your food defense system. They must be a qualified individual in terms of that they have the education, training, or experience, or a combination thereof, necessary to perform an activity required under subpart C of this part, which are the food defense measures, as appropriate to the individual's assigned duties. And they must also have successfully completed training for the specific function, at least equivalent to that received under a standardized curriculum recognized as adequate by FDA. Their job experience may qualify an individual to perform these functions if such experience has provided an individual with knowledge at least equivalent to that provided through the standardized curriculum. The food defense qualified individual does not need to be an employee at your facility, though it would be prudent to have a qualified individual there that can answer questions about food defense and be alert in case changes need to be made to the food defense plan. It is recommended that you also assign a food defense team to help write the food defense plan. This may be difficult if you're a smaller operation with few employees, but if you can put together a team from different areas at your facility who are directly involved with the different food processes and daily operations, the resulting food defense plan will be more thorough and effective. They can help identify areas of vulnerability that a person from another area may overlook. So the responsibilities of the food defense qualified individual are the preparation of the food defense plan. They must conduct the vulnerability assessment, identify and explain the mitigation strategies, and reanalyze the food defense plan at least every 3 years. So, a vulnerability assessment must be conducted for each type of food manufactured, processed, packed, or held at your facility using appropriate methods to evaluate each step on the process to identify significant vulnerabilities and actionable process steps. The vulnerability assessment in the food defense plan would be what a hazard analysis is in the food safety plan or HACCP plan. When we think of vulnerabilities, we have to understand that for the intentional adulteration, we would only consider significant vulnerabilities. A significant vulnerability means a vulnerability that, if exploited, could reasonably be expected to cause wide-scale public health harm. There might be other areas where there might be, vulnerabilities that would not impact the safety of your food in a wide scale. Just like in the food safety plan or HACCP, you must justify why each point, step, or procedure was or was not identified as an actionable process step. You must consider the potential public health impact. The estimate should include the potential acute illness, deaths, or both, caused by the addition of a contaminant at each point, step, or procedure. Then you would have to consider the degree of physical access to the product, which is the level of accessibility to the product at each point, step, or procedure. And then the ability of an attacker to successfully contaminate the product. This is how easy or difficult it is for an attacker who has obtained access to the product to introduce a contaminant and remain undetected to achieve the attacker's goal of causing wide-scale public health harm. You must also consider the possibility of an inside attacker. It could be a disgruntled employee, it could be somebody whose intention from the beginning was to cause harm to your company. You never know. So, sometimes doing like background checks and being a little bit more thorough in your hiring process can help, mitigate the risk for an inside attacker. FDA has approved the standardized curriculum that focuses on the CAT method, which is the Key Activity Types method. It identifies points, steps, or procedures consistently ranked as the most vulnerable, regardless of the food commodity assessed, and reflects significant vulnerabilities to intentional adulteration caused by acts intended to cause wide-scale public health harm. It is not the only accepted method. There are other methods to conduct vulnerability assessments. That is why FDA requires a qualified individual to conduct the assessment and write the food defense plan to ensure the use of an appropriate method. The key activity types were identified as activities that were the most vulnerable to an attack and were likely to cause the wide-scale harm. The 4 key activity types include bulk liquid receiving and loading, liquid storage and handling, secondary ingredient handling, and mixing and similar activities. When conducting the vulnerability assessment using the CAT method, you should assess each point, step, or procedure to determine whether the activities at the point, step, or procedure fit within one or more of the key activity types. The process steps that fit within one or more of the CATs are actionable process steps and require mitigation strategies. Mitigation strategies would be in a food defense plan what preventive controls are in a food safety plan. These are risk-based, reasonably appropriate measures to significantly minimize or prevent significant vulnerabilities identified at the actionable process steps and that are consistent with the current scientific understanding of food defense. For each mitigation strategy implemented at each actionable process step, you must include a written explanation of how the mitigation strategy sufficiently minimizes or prevents the significant vulnerability associated with the actionable process step. There are 2 types of mitigation strategies: personnel and operations-based or technology-assisted mitigation strategies. An example of a personnel and operations-based mitigation strategy would be to determine which personnel is authorized to be in a critical area where vulnerability exists. An example of a technology-assisted mitigation strategy would be implementing a physical access barrier or of tamper-evident seals or other detection mechanisms that would prevent access to someone intending to adulterate the food without leaving detectable evidence. The management components for mitigation strategies include the monitoring procedures, corrective actions, and verification. Monitoring procedures are the planned sequence of observations or measurements to assess whether mitigation strategies are operating as intended. The corrective actions are procedures that must be taken if mitigation strategies are not properly implemented. And then verification is ensuring that the monitoring, corrective actions, and mitigation strategies are properly being conducted, implemented, and are effective. This also includes the review of records and the reanalysis every 3 years, at least. These activities can be performed by line personnel, equipment operators, supervisors, maintenance personnel, or the QA personnel, if they've been properly trained in food defense to perform this specific task. Then, with every food defense plan activity, you must keep records for at least 2 years. The food defense plan must be kept at the facility at all times. Other records may be kept off-site as long as they can be retrieved within 24 hours. Food defense plans must be reanalyzed at least every 3 years, or if significant changes occur at the facility, new information is discovered, food defense plan is not properly implemented, or whenever FDA requires a reanalysis. So the compliance dates for the intentional adulteration rule already started for large companies who have more than 500 full-time equivalent employees in July of this past year. Facilities with less than 500 full-time equivalent employees will need to achieve compliance by July 27 of this year. And very small businesses have the opportunity to comply until July 26 of 2021. Very small businesses are exempt from the rule provided that they document that they meet the requirements to be exempt by the deadline. If you do not provide the documentation to prove that you meet the requirements for exemption, then you will be required to have a food defense plan. FDA announced its intention to start inspecting to ensure compliance with the intentional adulteration rule beginning of March of this year. So you were supposed to start compliance by July, but FDA will start verifying your food defense plans in March. The deadline for small businesses is also approaching quickly. And very small businesses should focus on their qualified facility attestations for their food safety plans. If you do not submit a qualified facility attestation, you will not be eligible to receive the exemptions as a very small business. FDA has increased their enforcement of FSMA related regulations during their past inspections this year, and hundreds of facilities have been cited for FSMA violations. So we're going to go over some consequences of when compliance is not achieved. If FDA is inspecting your facility and they find they have negative observations regarding your GMPs or your food safety plan, your HACCP plan, you will receive first and foremost a Form 483. This is where they're going to list those observations at the end of the inspection and will allow you 15 days to provide a response on how you're going to fix the issues listed on those observations. If you do not provide a sufficient evidence that you are properly addressing those issues, FDA can then issue a warning letter. And when we will go over warning letters in the following slides. Also, FDA could force you to recall your product if there is a significant hazard associated to a product that already went out to the market. Another way to to hold your product would be to do detentions and refusals at the port. Once the product is inspected at the port, like Anna mentioned, if your label is not compliant, they will detain your product and can refuse it right there at the port. Import alerts, if you do not address issues, you've had many issues during the past years, or if there's a very significant hazard associated to a product that came through the port, FDA could put you on the import alert list, which is just detention without physical examination of your product, and it will not be examined. It would just be refused, and it could not come into the country. They could suspend your registration, which is also a way of not allowing your product into the United States. They could do seizures and injunctions, civil and criminal charges against you, and it would bring collateral damage to your company image. Some common FSMA violations for 2018, they were issued, companies were issued around 2,583 citations during their inspections. FDA cited 278 U.S. importers for not developing their foreign supplier verification program. FSBP violations more than doubled from 2017 due to the larger amount of inspections conducted to the importers. So in relation to preventive control violations, FDA issued around 396 citations during their inspections, and these included not having a HARPC food safety plan, not identifying all the hazards and establishing the proper controls, not designating a preventive controls qualified individual, and not monitoring sanitation, allergen controls, and improper record keeping. 1/4 of all inspection violations for 2018 were FSMA related. So as we can see, the preventive controls were 15%, and for FSBP, they were 11%, and then other inspection violations were 74%. This could be GMPs, which is mainly the area where facilities really drop the ball sometimes. Then, as we mentioned, that warning letters could be issued to your company. Facilities must respond to the warning letters within 15 days, or they can receive other regulatory action, which can include import alerts, refusals. Reasons for receiving a warning letter in 2019 were for failure to develop the HARPC food safety plan, leaving out a component of a food safety plan, not properly implementing the food safety plan at the facility, and then for importers not having an FSBP. When FDA finds that a manufacturer has significantly violated the FDA regulations, FDA notifies the manufacturer via the warning letter, and after notification, FDA expects a proper response, and if that is deemed insufficient by FDA, and can result then in further regulatory action. So for FSMA, most of the preventive controls and FSBP compliance dates have passed. So everyone should be compliant, who this applies to should be compliant by now. Some produce safety requirements would be due between 2020 and 2024 regarding agricultural water requirements. Then the intentional adulteration dates began July of this past year, but FDA will start enforcing that for large facilities in March when they start inspecting for those. Then they extended the dates for small and very small businesses, and you can find more information on these compliance dates at the following link.
All right, I know that this webinar is called the 5 Things Food Exporters Need to Know about compliance in 2020, but I think the 6th thing that food exporters need to know is how Registrar Corp can help you. Registrar Corp's services include registration and renewal for food facilities, and this includes assistance to obtain and maintain your DUNS number, which is scheduled to be required as of October 2020. We also offer labeling and ingredient review, as well as the review and development of FSMA programs, such as the HARP-C food safety plans, foreign supplier verification plans, and food defense plans. Registrar Corp is offering a 10% discount to all webinar attendees through February 14th on any of these services.
Thank you all for that great presentation. Again, I'd like to announce that we will be sending a recorded copy of this webinar and a PDF copy of the presentation to all registrants. You may still submit a written question by using the Ask a Question feature in the top center of your webinar screen.
Okay, so the first question that we're going to address, the question is, are these label requirements also for business-to-business products? So there are some exemptions from the nutrition labeling specifically that address products that are being sold and intended for further processing or further packing, products that are shipped bulk and wholesale from one manufacturer to another, and with the intention that they either be further modified or packed into retail containers at that point. So the exemption is specific to that nutrition facts panel. And it's sorry, the way that the regulations are written, that is the only specific exemption. So we strongly recommend that the remaining mandatory declarations appear on the package of the bulk label that is accompanying the shipment. Okay, another question is, when talking about significant amounts of nutrients on the label, what do you mean exactly? What amount? So when FDA is talking about significant amounts of certain nutrients, they have cutoff values below which a nutrient can be declared as zero and considered insignificant. So it varies widely depending on the nutrient itself. So for example, with total fat, it would be 0.5 grams. For a lot of the vitamins and minerals, it would be considered less than 2% of the daily value for that nutrient. And this comes into play when you're talking about whether or not you qualify for what's termed the simplified version of the nutrition facts chart. And then also, if you're allowed to be exempt completely from the nutrition facts chart, for example, commodities such as coffee and tea don't have any nutrient values, and so therefore they're exempted completely from the chart. It also comes into play as to when you can use the not a significant source statement at the bottom of a nutrition facts panel in order to save some space. Okay, another question, if the servings per container is 2 or 3 and the percent of the rack is more than 300%, what type of nutrition facts do we need to declare? So the way that the regulation is written, it's written where if the amount of the package is 200 to 300% of the reference amount, then the dual column is required. That can get a little bit tricky because if you're particularly savvy, which it sounds like this commenter is, it can get a little tricky because the serving size that's declared is not always exactly the same as the reference amount. So in a case like that, you want to read the regulations really carefully to see whether or not you're required to comply with the dual column labeling.
So a question related to the intentional adulteration is, does the U.S. importer FSBP have to ensure the foreign supplier's firm have to implement FSMA intentional adulteration? So no, the FSBP would only address that the foreign manufacturers are in compliance with the preventive controls rule, with the produce safety rule, with labeling in regards to allergens, and that they also comply with the dietary supplement CGMPs. So they would not have to make sure that they have a food defense plan. However, you could, as an importer, you can ask in a questionnaire, do you have a food defense plan in place? And that should be enough because food defense plans cannot be shared outside of the company. Another question regarding this is, we only export animal treats. Do we have to document that we are exempt, or do we do nothing because we know we are exempt? So when submitting your food facility registration, you have declared that you are making animal food, so FDA would not ask you to provide this documentation, because they would already know prior to inspecting that you manufacture animal food.
Okay, we have a question that says, hello. To sell in the USA, must we have an FDA number? My question is, if the product isn't a medical or alcoholic beverage product, should we register? We would like to sell malt beverages to our client in Florida, and we would like to make sure about the requirements. So the requirement for any food facility, if you are manufacturing, processing, packing, or storing food at your location that you own or operate, then you are required to register as a food facility with FDA.
We have a question regarding FSBP. Is the FSBP the same as the Food Fraud Prevention Plan? No, it is not. The Foreign Supplier Verification Program is where you apply an evaluation for approval of your foreign suppliers. You must conduct a hazard analysis regarding the safety of the food. Food fraud is not considered related to food safety, because a food fraud doesn't necessarily result in harm to the consumers. It's just lying to the consumer. So it won't necessarily cause them any illness or death. So you would have to make sure, as I mentioned, that they are complying with the preventive controls, produce safety, or the CGMPs for dietary supplements, and in case of low acid canned foods and acidified foods, that they also comply with those regulations. You would also have to, after conducting a hazard analysis, then determine the verification activities for that particular food that you are importing.
Okay, we have a question about corn and soybeans. How can a supplier prove the product is not bioengineered? Is there a special form? So at this point in time, USDA is taking comments from industry regarding the validation procedures for this sort of thing. And so there isn't an actual submission that's required at this point. We anticipate that it'll be a matter of record keeping. So if USDA asks if you have corn or soybeans in your product, for example, and there's no bioengineering disclosure on the labeling, they would want to see record keeping. For people who have corn and soybeans that they are confident would not fall under the disclosure rule, you'll probably want to pay close attention to what USDA is publishing and perhaps submit comments because they'll be issuing guidance at a minimum, most likely within the next year, regarding those validation procedures and the testing procedures to determine whether or not bioengineered genetic material exists in a particular product.
Regarding food defense plans, does the food defense plan include HACCP guidelines to be followed, especially in mitigation strategies? You must not confuse food defense plan with HACCP plans. They are only similar in that they are a preventive approach, but they are not related. So the mitigation strategies and actionable process steps and all these identifications that you have to do, you would have to take the food defense training to be able to develop your food defense plan, but it would not be similar to HACCP.
We have a great question about DUNS numbers from Jennifer Anwar. Jennifer asks, do foreign producers require a DUNS number, or does this apply only to the USA importer of record? So that's a great question, because until now, the DUNS requirement, as far as food facilities are concerned, has only applied to US importers. But what's interesting about the UFI requirement that we're talking about today is that it does apply to both foreign and domestic companies. So all registered food facilities are going to be required to have this unique facility identifier starting in October of 2020.
Okay, we have a question that says the alcoholic beverages beer should also include the nutrition facts table in accordance with the laws and regulations, or is this not obligatory? So alcoholic beverages are sort of divvied up in terms of jurisdiction between TTB, our Alcohol Tax and Trade Bureau, and the FDA. So only those alcoholic beverages that are subject to FDA regulation in terms of labeling are the ones that would have to have the nutrition facts panel. So if it's a beer, it would depend on really the nature of the beer. Beers, regardless of alcohol content, that are made with malted barley and hops, with or without any other type of grain, are subject to TTB regulation and therefore would be exempt from the nutrition facts label. Beers that are made with sorghum and just wheat, no malted barley or hops, and then also wines that are less than 7% alcohol fall under FDA jurisdiction. And so those products would be required to have the FDA Nutrition Facts panel on the label.
Question from Amelie. Do warehouses which are storing food also need a food defense plan, or only producers and companies coming directly in contact with the food? So no, warehouses do not need to comply with a food defense plan unless they are storing liquids. So if it's liquid storage tanks, yes, you would need a food defense plan. But otherwise, if it's packaged food and you're not processing, you're not exposing that food to the environment, you do not require a food defense plan.
Okay, we've got a question about bilingual labeling, whether it's a must or if it is optional. The general requirement is that a food label should have all the mandatory declarations in English. Then the way the regulation is written, if any of that mandatory information is presented in another language, such as Spanish or French or German or Chinese, then all mandatory declarations need to be repeated in that language. There are some exemptions for U.S. territories where English is not the primary language, but by and large, you're going to want to make sure that all those mandatory declarations are in English, and be very careful if you add a second or third language to the product label, because that will kick in the requirement for all the mandatory declarations to be presented in those languages as well.
We have another DUNS question. If the facility already has a DUNS number, should it be renewed every 2 years as well? And if so, will the number change? There is not a mandatory renewal process for DUNS numbers. However, the unique facility identifier does need to correctly identify your facility, so it should be updated whenever your facility's name or address changes, and that is something that Registrar Corp can assist you with.
Okay, we have a question about GMOs and the bioengineered food. Are GMOs considered bioengineered food? The best answer to this is simply to go back to how USDA has defined bioengineered food. And so by and large, the two are probably synonymous. Again, the bioengineered food definition is food that contains genetic material that's been modified through in vitro recombinant deoxyribonucleic acid techniques, and for which modification could not otherwise be obtained through conventional breeding or found in nature. And so if the ingredient and your definition of GMO falls in and is synonymous with that, then it would be considered a bioengineered food.
All right. We will now take our final question.
Do the farms need a food defense qualified individual? No, they do not. Farms are exempt from the food defense rule.
Okay, we are out of time, but you can send us any additional questions anytime by email to info@registrarcorp.com. This concludes our presentation, and thank you for joining us today.